Companies Act, Section 97, Power of Tribunal to call Annual General Meeting. Section 97 of the Companies Act provides the tribunal, which typically refers to the National Company Law Tribunal, or NCLT, with the power to intervene in situations where a company has failed to hold its Annual General Meeting, AGM, as required under Section 96. This section empowers the tribunal to call an AGM of the company, overriding the provisions of the company's Articles of Association and ensuring compliance with statutory requirements. This provision plays a crucial role in enforcing corporate governance practices and ensuring that shareholders have the opportunity to engage with the management of the company. Below is a detailed breakdown of Section 97 and its implications. Subsection 1. Power of the tribunal to call an AGM. 1. Failure to hold AGM. Section 97, 1, comes into play when a company fails to hold its AGM within the prescribed time frame under Section 96 of the Companies Act. As per Section 96, every company, other than a one-person company, OPC, is required to hold an AGM in each financial year, and if this is not done, there is a legal default. The failure to convene the AGM within the statutory time limits triggers the provisions of Section 97. 2. Tribunal's authority to intervene. If the company has not held its AGM as required by law, the tribunal has the authority to intervene and take action. The tribunal can be approached by any member of the company who is concerned about the failure to hold the AGM. This gives shareholders the legal right to request the tribunal's intervention if they feel that the company is neglecting its obligations under the law. The tribunal has the discretion to call or direct the calling of the AGM by issuing appropriate orders. This ensures that the company complies with the statutory requirement of holding an AGM and that the interests of the shareholders are safeguarded. 3. Override of company's articles. Importantly, the tribunal's power to call the AGM supersedes the company's Articles of Association or any other provisions within the company's governing documents. This means that even if the company's articles provide different provisions regarding the timing or manner of holding the AGM, the tribunal's direction will take precedence. The overriding authority of the tribunal ensures that statutory compliance is upheld, regardless of any internal rules or restrictions set by the company. 4. Ancillary or consequential directions. In addition to ordering the holding of the AGM, the tribunal can issue ancillary or consequential directions that it deems necessary or expedient. This could include ordering certain actions or arrangements related to the meeting, such as the setting of a specific date, location, or agenda for the AGM, or ensuring the proper communication of the meeting to all members. These directions allow the tribunal to ensure that the AGM is held in a manner that complies with legal requirements and that shareholders are given due notice and opportunity to participate. 5. Deeming of a meeting to be valid. A specific provision allows the tribunal to direct that one member of the company, who is either present in person or by proxy, shall be deemed to constitute a meeting. This is particularly important in cases where the company may have failed to hold the AGM for an extended period and it is not feasible to gather a quorum. The tribunal can thus ensure that at least the minimum statutory requirement for holding an AGM is met, even with limited participation. Subsection 2. Status of general meeting held under tribunal's directions. 1. Deemed AGM. Once the tribunal has directed the holding of an AGM in accordance with the provisions of Section 97, the meeting that is held under such directions is treated as a valid AGM of the company. The meeting, despite the tribunal's intervention, will be deemed to be an AGM as required under the Companies Act, subject to any additional directions issued by the tribunal. This provision ensures that any AGM convened under the tribunal's directions is considered to have met the legal requirements for an AGM. Shareholders' votes, resolutions passed, and discussions held at the meeting are all considered valid and legally binding. 2. Tribunal's discretion. The tribunal may provide specific directions regarding the procedures, resolutions, or other aspects of the AGM. For example, it might dictate how the AGM should be conducted, what matters should be discussed, or how resolutions should be passed. These directions help ensure that the meeting is held in compliance with the law and provides for shareholder participation. Purpose and implications of Section 97. 1. Enforcement of shareholder rights. One of the primary objectives of Section 97 is to protect shareholder rights by ensuring that an AGM is held regularly and in accordance with the statutory timelines. If the company fails to call the AGM, shareholders can approach the tribunal, thus enabling them to exercise their rights to be informed about the company's performance and to participate in key decisions such as the appointment of directors or approval of financial statements. 2. Accountability and corporate governance. Section 97 reinforces accountability in corporate governance. By providing a mechanism to compel companies to hold their AGMs, the section ensures that management is transparent and accountable to shareholders. The tribunal's intervention ensures that even in cases of corporate neglect or mismanagement, the company complies with legal obligations. 3. Preventing mismanagement. The provision serves as a safeguard against mismanagement by companies that might deliberately avoid holding AGMs to avoid scrutiny or shareholder participation. It ensures that shareholders are not deprived of their opportunity to hold management accountable and engage with the company's operations. 4. Legal remedy for shareholders. The right for shareholders to apply to the tribunal provides them with a legal remedy when a company fails to fulfill its obligations under the law. This provides shareholders with confidence that they can seek redress and compel the company to comply with statutory requirements. For more details, contact us.